Welcome to the Business Law, Estate Planning, and Estates Podcast.
Hello, and welcome back to the Business Law, Estate Planning, and Estates Podcast with attorney Thomas LaPorte. Thomas is the founder of LaPorte Law Group with an office in Portsmouth, New Hampshire, and a location in Andover, Massachusetts. With more than 30 years of experience, he helps individuals, families, and business owners protect their assets, plan for the future, and navigate estates and business matters with clarity. I'm Leanne Lyon, and today we're talking about what an LLC operating agreement is, what it should include, and how the right structure can protect your business from costly disputes down the road. Thomas, for listeners who are new to a business formation, what exactly is an operating agreement and why does it matter?
An operating agreement is an optional document, but it really shouldn't be optional for persons that go into business. They file with their state secretary of state a document that creates a limited liability company known as an LLC. Now, with a corporation, which is the other alternate, and there's partnerships and things of that nature, but LLCs and corporations give you a modicum of personal protect division of your personal assets from your business activities conducted through the LLC or the corporation. But an operating agreement is the equivalent of bylaws that a corporation has and is required of a corporation. So an operating agreement just sets forth the ground rules as to how the company will operate, what it does, and what its members, the owners of an LLC are called members instead of shareholders, but essentially they're the same thing. But it sets forth various rules for various scenarios and situations that will come up almost inevitably, particularly when there are more than one owner, 2 owners, 3 owners. Disputes arise and you identify those disputes in advance and expectations, and you put them in an operating agreement, and everyone signs off on it. That's what it is.
So what key elements should every operating agreement include?
You need to set forth what items are going to require just a simple majority vote. The day-to-day operations. If there's an extraordinary decision, say for a new business starting out or a small business, that might involve an expenditure of $5,000 or $10,000, for instance. It's a big deal, not in the ordinary course. You're buying a piece of equipment. That might require unanimity. Or if there are 3 members, for instance, 2 out of 3, which is called a supermajority, which is 66 2/3% versus 50%. So voting rules. The expectations, who's going to do what? Is one person going to be responsible for sales, the other one responsible for the back office responsibilities? You divide up and you write down what those expectations are. So job responsibilities. Thirdly, capital contributions. How much money is each going to contribute? Are there going to be events where or a timeline where more money has to be infused in the company, or is more money required for certain agreed upon in advance items and things? Leasing a building, for instance, because the company's growing, which is a good thing. A couple of other things that are important. Myself and you, Leanne, we're an LLC together. You want to sell your membership interests, your shares, if you will, to somebody else. Well, who do I know? Who is this person? Does this person have expertise in the donut making company that we're setting up, for instance? I don't want to be in business with someone who doesn't know what they're doing. But you own these membership interests. You can sell them to whoever you want. So we want to put transfer restrictions in there. And a simple example is, Lisa, if you get a genuine offer from a third party to buy your shares, your interest, well, I get a right of first refusal. I can match that. So they keep the donut making business within my control because I know what we're doing. And you're leaving, but Joe Jones, who wants to buy the shares, I don't want to be in business with Joe Jones. I don't know him. He doesn't know me. Maybe it's a female Joe Jones, Josephine. I don't know. And we can structure that so that if you're leaving, Leanne, then perhaps we agree on agreed upon price in advance, or we agree how to appraise it at that time with an evaluator. Um, if I've used 3 evaluators or 2, and we average the valuation if we disagree on the price. We can set that up in advance. Maybe I need time to buy you out. You want your money as soon as possible. I want time enough to do it. We agree on the interest rate and a term, say 5 years, 2 years. Those things ought to be in an operating agreement. Um, Sometimes things are going along well, and the 4 Ds happen. One of us, I just gave it an example, the first D, which is departure, but we all die. That's the second D. One of us may become disabled for 6 months or more and can't carry out their functions within the operating the company, or one gets divorced. LLCs are assets that are subject to property division within a divorce. So we can have an agreement that in the event that happens, and usually have the spouse's consent to this, by the way, in writing, I get, in this case, you're disabled. I'm using you as the fall person all the time. I'm sorry, maybe it's me. You get to buy out my spouse. I get to buy out your family, your spouse. Again, on terms that we agree to in advance. And we want to have your beneficiaries if it's death, your spouse if it's divorce, for instance, agree to that in advance. There's ways to fund that. What if there's not a whole lot of liquidity in the company? Well, we can buy insurance. We can buy insurance, disability insurance, to fund that buyout, or life insurance. Sometimes the best dollar ever spent is it costs 10 cents in premium dollars for 100% of coverage. So it's a good way to leverage insurance to fund these buyouts for these events that may happen, the 4 Ds, if you will. These are some of the things that I like to have in an operating agreement.
It makes a lot of sense. So I've heard of member managed and I've heard of manager managed structures. How does a business decide which one to use?
Yeah, really good question. Member managed, and they're more popular. There are more small businesses in this country than any other types of businesses. About 85% of the businesses. A member managed is you and I used my scenario. Leanne and myself are in the donut making business. We're both member managers. It's more of a democratic, egalitarian, collaborative way of managing the company. If as we get a little bit more mature and we want to have more expertise, then we may appoint a manager. And it doesn't even have to be a member. It could be a manager member. Perhaps this manager member has a particular managerial expertise that you and I don't have. Or say there are 10 members with an LLC. There are 3 of the 10 that have that managerial expertise. They're going to be subject, of course, to the members' supervision, and we write those rules into the LLC too. So if there's a specialized person within the group that can focus on management, and the members can do the other things that they're good at, say sales on one hand, manufacturing on the other, you'd have a manager managed LLC in that case. It's usually from a little bit more mature limited liability companies than, say, the startups.
So you talked earlier about voting, a supermajority, different things like that. What types of decisions typically require unanimous consent versus majority approval?
Another great question. The substantial, extraordinary decisions. We're going to sell the business. That usually requires at least supermajority or unanimity. Everybody has to be on board. Transfer of substantially all the assets. So say there's a company that wants to buy the assets out. And usually an acquiring company only wants to buy your assets, not the whole company, because of the contingent liabilities, claims with a roofing company, for instance. The roof wasn't done 2 years ago. They buy the company, they're buying that potential claim. sale of the company, sale of all of its assets or substantially all the assets, um, dissolving the company. We're just not going to do this any longer, or it's not working out. Those are the types of large, substantial, extraordinary, not day-to-day decisions that would require a unanimous vote.
How about internal disputes? Does the operating agreement have anything to do, or can it help resolve those before they happen or when they happen?
Yes, you can put a mechanism, just like in any contract, uh, uh, in place. For instance, I like to say the parties will agree in good faith, and we Americans tend to psychologically affix an obligation to honor our signatures on a piece of paper, on a contract, on an operating agreement. So, getting back to the types of dispute resolution mechanisms, we're going to agree to negotiate in good faith. And if that doesn't work, we're going to agree to use a mediator we both agree upon. If we can't agree upon that, then we'll have the company attorney or the company accountant decide who that will be, and we're stuck with that. It can be mediation is usually non-binding. We can agree, look, we're going to mediate for 4 hours. And if that doesn't work, we're not going to waste our time anymore. So the next step would be either we'll agree to non-binding or binding arbitration. And you can choose who that would be. You can choose to use arbitration rules from, say, the American Arbitration Association or NJAS, but not their arbitrators because they're so expensive. So these private dispute resolution mechanisms usually avoid the not talking to each other. Next thing you know, one's filing suit in court and we're in litigation and off we go. Um, uh, that's a way to manage and reduce conflict. And it really is a deterrent and sort of preventative measure too, I think. Um, so those are what I like to put those in, but explain all the options to the members, and they agree to that in advance. And I think it tends to have members that are going to business with each other agree to get along. You know, they're doing so right from the get go by agreeing to some of these provisions in advance. So
Good point. Absolutely. So, what responsibilities should be clearly defined for each member or each manager?
certainly the division of labor. There should be a job description for each member, just like you would with an employee. There should be a set forth in writing the expectations of how much money each of us has to invest and when and for what purposes. You know, do we agree that we want to, if we're in the trucking business, we want to buy 2 trucks per year? We need to agree in advance that we're going to set aside from our own personal funds money to contribute for those types of purchases. And hopefully the company will become cash flowing of itself so we can use the company money. Um, so division of labor, job duties, uh, contributions, which are monetary, they're also called capital contributions. What else? We touched upon voting rights. We touched upon rules regarding transfer of interests outside to third parties. What happens again if someone departs or there's a divorce? Um, there are other ground level type provisions that ought to be put in the LLC as well. Um, another are look, Leanne, if you want to go out and start your own donut making business, you can't compete with me. You can't, or I can't compete with you. That'd be unfair. You've learned the tricks and the trades of selling donuts in Topeka, Kansas, for instance, or Portsmouth, New Hampshire. You can't take that institutional knowledge and compete across the street with me and non-compete confidentiality agreements. We're in this together. We're not going to turn around and um, be rivals and competitors. Those types of things ought to be in an agreement, as well as compensation, if there's going to be compensation or when that will be triggered.
So, you talked earlier about the 4Ds. How does the operating agreement address those?
It addresses the 4Ds are events, they're life events. And by the way, I do applaud you for the provision with your LLC fellow member. Yeah, none of you should be able to go out and spend, the crown jewels without the authority of the other. That's a very good point. The 4Ds involve departure, death. I guess that's a departure, right? Divorce, where the LLC becomes part of the divorce member's property division that the divorce court or the family court judge can divide amongst his spouse, her spouse, and disability that doesn't resolve itself after, say, 6 months. So I'm disabled. I can't contribute to the LLC and you're on your own. Well, what happens in that case? It's not fair for me to be disabled and Lisa, you're carrying the weight of the LLC, the whole business world on your shoulders. So we would put in place an agreement in advance that in those scenarios, in this case, Lisa, you would have the right to buy out my interest. We agree in advance how that's going to be valued at the time. Fair market value, and we use various business appraisers. It's not that expensive. Sometimes we agree to purchase life insurance for the death departure or disability insurance in the scenario that I get disabled or you do. And we use that to fund the buyout. And the buyout can be structured. It doesn't have to be a lump sum payment. Usually that's not attainable in many cases. So we agree to a term of years with a reasonable interest rate. In the event of, for the divorce departure, we want to have, in my case, I'm getting divorced. Don't want to, but it's happening. We will have each other's spouses agree to these provisions called the spousal consent. It's all agreed to in advance, and that's how you handle the 4Ds, if you will.
Well, that is it for today's episode of the Business Law, Estate Planning, and Estates podcast. If you'd like to learn more about attorney Thomas LaPorte and his work at LaPorte Law Group, visit laportelawgroup.net. Thank you for listening, and remember to subscribe, share this episode with somebody who needs to hear it, and leave a review. Thank you, Thomas.
Thank you, Leanne. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.